Welcome. My name is Reuben Tylor. I'm a New Zealand barrister and I'm a shareholder and director of Trustees and Fiduciaries. I'm going to talk today about some of the technical aspects of Cook Islands asset protection law. If we have a look at this chart, you'll see that our law in the Cook Islands is quite different to other law in other countries. And I'll just go through each of these elements. First of all, the statute of limitation. An action alleging a fraudulent transfer must be filed in a Cook Islands court within 2 years of the date of the transfer of those assets. Otherwise, that action is going to be time barred. The time limit relates to each transfer of assets to a trust, so that if one transfer is voided, then it does not affect any other transfer, and that's an absolute rule. Next item is fraudulent transfer law. Our fraudulent transfer law is old law. It has two tests that are in addition to the time limits set by the limitation statutes. The first test is that the creditor must establish intent to defraud, and the second test is that the creditor must establish that the settlor was rendered insolvent by the transfer of the asset. Now, both those tests are personal to the creditor, and both tests have a criminal burden of proof which is beyond a reasonable doubt. Intent. The statute contains irrebuttable presumptions against intent. If the assets are settled 2 years after the date the cause of action accrued, or if the creditor fails to commence proceedings within 12 months after the settlement of the asset. So in that situation, the creditor is unable to argue that there is an intent to defraud. Now, that presumption does not apply if the proceedings alleging fraudulent transfer were filed in any court prior to the transfer of assets. The statute also rebuts what are known as badges of fraud. So if you settle the trust within 2 years of a date of cause of action accruing, then there is no presumption that you had intent. Likewise, if you retain powers to control the trust, you will not be deemed to have intent. Likewise, if you are a beneficiary, a trustee, or a protector of a trust, and likewise if you settle the trust after proceedings are issued. In dealing with intent, there is also detailed legislation dealing with the question as to when the cause of action accrues. In particular, where there are multiple causes, then the statute directs the first cause to be the relevant event. Where there are continuing causes, it is the first instance that is considered for the purposes of the time limits. Solvency. We don't have bankruptcy law in the Cook Islands. As a consequence, solvency is assessed in relation to a specific creditor. The consequence of fraudulent transfer is also different. The trust establishment itself is not voided, and other transfers of assets to the trust are similarly not avoided, which means that you still have protection from other creditors. But the trustee is directed to settle the specific creditor where fraudulent transfer is found. When the trustee settles the creditor, the settlement must be limited to the value of the asset that has been found to have been transferred fraudulently and any accumulation to its value, but it does not extend to other assets. The creditor must also exhaust remedies against any other property belonging to the settlor and held outside the trust, and he must also exhaust any rights of appeal in the United States. Finally, any exemplary or punitive damages are excluded from any claim against the trustee. Our procedural law is also important. The main purpose of the law is to prevent fishing expeditions by clients or bankruptcy. I've already mentioned that we don't have bankruptcy law, which means that we have no recognition of a trustee in bankruptcy and also no application of clawback provisions. Contingency fees and costs. This is important. We don't have provision for contingency fees in our law, costs, you will be liable for full costs if you fail to prove fraud. Finally, security for costs. You can expect to be asked to provide security for costs in all cases. In summary, the Cook Islands provides a comprehensive asset protection regime. It gives clear legal advantage to settlors of a trust.